We've seen an increased use and reliance on AI in a lot of the tech providers. We do an annual legal and compliance conference every spring in the US, and we've had major boosts in the number of exhibitors who are willing to come and talk about what they can do. Compliance solutions can be automated. You're always going to need a human to help develop and interpret the rules, but even that, I've seen legal tech firms try to digest rule changes. The ability to update as rules update. Circulars from the exchanges can be digested and interpreted. Even FIA has services around CCP rule updates.
How will new European clearing models affect market participants?
It actually concerns a project FIA has had underway for many years now. It's focused on, at bottom, creating more capacity for clearing. With the model we are so familiar with in US being the agency model for clearing, that can allow for more capacity generally from the banks. In Europe, where the model is principal to principal, there is a constraint on the G-SIFs. So especially for US-based G-SIFs, there is a capacity constraint on their capital for them to offer clearing services in a principal-to-principal model. The project that you're asking about was born out of a project we pursued with Linklaters to develop a model in Europe based on the US-style agency clearing model, but with the same protections available in Europe. So it's based on a trust model, which allows us through the trust, the law of trust, and contract to create what is essentially an agency model. The real goal is capacity. We can actually allow G-SIFs who are willing to participate in this European agent trustee model to offer more capacity to their clients for clearing.
What are the implications of the U.S. Treasury sharing mandate for European market participants?
We are very busy handling it in the U.S. We still have outstanding questions in the U.S. from the regulators, from the clearinghouses, from the vendors. How will this model really function? We're still developing, for example, client documentation. But in Europe, we have outstanding questions from the mandate itself about who in Europe must comply. So you have sort of that obvious market impact where U.S. Treasuries being as important as they are globally, there will be a change to the market. And I think everyone in the world is looking at that. But in addition, while there are some exemptions in the mandate for inter-affiliate transactions, it's not clear the boundary of those. The industry has asked the SEC for some guidance on that and for some clarity on the exemptions, but they're not out yet. And so the questions remain as to specifically who is subject to the mandate. Even European-based banks with a European-based client may be subject to the clearing mandate. And that's what we're looking for the regulator to settle for us.
How is tokenization transforming collateral management?
To me, it has massive positive implications for those clearing members who are on the hook over periods between settlement cycles. So in particular, over holiday periods or even over weekends, it's really the FCM that holds that burden and bears that risk over that period. If we had faster settlement of collateral, more frequent settlement cycles because the money could move as fast as the settlement cycles did, it really would benefit clearing members who are currently holding that risk over periods of time. There's been a lot of inquiry about 24/7 markets and trading. In our view, it's hard to move to 24/7 markets if we do not have more frequent settlements and closer to 24/7 settlements. That's hard to do without the movement of collateral on also a 24/7 basis. So whether we ever get to that or not, I don't know. FIA filed a comment letter in response to a CFTC request for comment on 24/7 trading markets. And it's not just the unavailability of fast collateral settlement that's holding us back. It's things like some firms don't want to staff 24/7. It's not everybody wants to trade, particularly some agricultural products all the time. But that collateral movement is really could bring true efficiencies to the clearing cycle.
How are regulatory and market changes affecting industry documentation and legal opinions?
The contracts really underpin all the rights, and that includes the rights to then net. I think for us, we're constantly updating the netting opinion suite we offer to members. Doing that at an industry association can help bring efficiency to firms, so they're not all buying the same opinion. So we've had a long-standing project in both the UK, Europe, in the US driving towards those opinions. Something like Treasury clearing requires new documentation. The clearing system is different. The clearing roles, rights, and responsibilities are different. And so we're drafting those new documents now. Once we do that, we'll need netting opinions for members to be able to reap the benefits of netting and cross-product margining.
How can the industry ensure new clearing models, tokenization, and legal tech stay secure and compliant across jurisdictions?
We regularly have members raise questions and say, this is something we considered, or this is something our risk and compliance group has asked. The opportunity to speak to others that sit in a similar seat that you do is one of the benefits joining an association can bring. So we have a number of junior staffer forums. We have a compliance officer group. And really what they do is ask the questions that they're asking internally, their colleagues are asking internally, or regulators are asking them. The opportunity to discuss what best practice is can be a really big benefit. I think it is a struggle to manage all that across different jurisdictions, all with different rules. But I do think talking to others in the industry that are in your same seat can help give you some guidance on how to manage the risks as they evolve.